Every day, millions of Americans keep a firearm in their vehicle. Most do it for the reason that makes immediate intuitive sense. The firearm is protection, and your vehicle is often where you are most vulnerable, in a parking lot, at a rest stop, at a gas station at night, stopped at a traffic light, in an unfamiliar area. But before June 5, 2026, the legal framework governing a gun in your car was one of the most chaotic and dangerous minefields in American firearms law. Dangerous not because of the firearm, because of the law surrounding it. A gun in your glove box that was perfectly legal in Texas could make you a felon in New Jersey. A loaded firearm in your center console that was protected in Georgia could result in a felony charge in California. The laws changed at every state line, sometimes at every city limit, and people were arrested, convicted, and imprisoned over firearms in their vehicles that were purchased legally and kept the way any reasonable person keeps a firearm intended for protection. That era ended on June 5, 2026, when the Supreme Court issued a unanimous 9-0 decision in Hargrove versus Ohio and permanently changed the constitutional framework governing every gun that every American keeps in every vehicle anywhere in the United States. If you keep a gun in your car, if you drive through multiple states, if you stop for gas in New Jersey, or eat dinner in Maryland or visit family in Massachusetts, this ruling is for you. And the details matter enormously. Because while Hargrove resolved the major questions, it left specific situations unsettled, and those unsettled situations are exactly where gun owners are getting into trouble in the weeks and months following the decision. Subscribe right now because what Hargrove versus Ohio established, what it left open, which states are still creating traps for armed drivers, what the traffic stop framework looks like after Hargrove, and what you must do before your next road trip are all questions this video answers in the detail. Gun owners who keep firearms in their vehicles need and deserve. Ryan Hargrove was an Ohio resident, licensed to carry, who drove from Columbus to Philadelphia for a family event. He had a legally owned, loaded handgun in his center console, legal in Ohio. He was pulled over in Pennsylvania for a cracked windshield. The Pennsylvania officer saw the firearm, noted Pennsylvania does not honor Ohio licenses, and arrested Hargrove for carrying without a license. Hargrove was convicted, sentenced to 18 months probation, and lost his right to own firearms for 5 years. He appealed, arguing the Second Amendment protected his right to keep an arm in his vehicle. The Third Circuit upheld the conviction. The Supreme Court reversed 9-0, and the decision produced a comprehensive constitutional framework for vehicle carry that affects every gun owner in America every time they get behind the wheel. Number 1. The Home Extension Doctrine, the constitutional foundation of Hargrove. What the doctrine establishes. Justice Elena Kagan, writing for all 9 justices, held that a vehicle is a mobile extension of the home for Second Amendment purposes when the vehicle owner or lawful operator is present in or immediately adjacent to the vehicle. This is a constitutional holding, not a statutory protection or a regulatory accommodation. The home has been the core of Second Amendment protection since Heller. Kagan extended that core constitutional protection to the occupied vehicle, grounding the extension in the same constitutional text, historical tradition, and self-defense logic that Heller used to protect the home. The historical reasoning: founding-era Americans traveled with firearms as a matter of necessity and custom, carried in wagons and on horseback as ordinary equipment for any journey. The historical record shows no founding-era tradition of restricting firearms in vehicles or their historical equivalents. Modern restrictions, requirements for locked cases, mandatory separation of firearms from ammunition, prohibitions on loaded firearms in passenger compartments, requirements for trunk storage, are inventions of the modern regulatory era with no historical analog. Under the Bruin historical tradition test, restrictions without historical analog fail constitutional scrutiny. What Hargrove struck down for present vehicle operators. States cannot require vehicle operators who are present in or immediately adjacent to their vehicle to store firearms in locked cases, separate ammunition from firearms in the passenger compartment, store firearms unloaded in the passenger compartment, store firearms in trunks or inaccessible areas. The firearm can be loaded, accessible in the center console, the glove box, the seat pocket, on the seat, or on the operator's person, all constitutionally protected when the operator is present. This eliminates the core of California's vehicle firearm requirements, New Jersey's loaded vehicle prohibition, Massachusetts vehicle transport requirements, Maryland's handgun and vehicle laws, and similar requirements in Connecticut, Hawaii, Delaware, Rhode Island, and Illinois. Number 2, interstate travel. The constitutional floor Hargrove creates. The travel protection. Kagan held that the Second Amendment right to keep and bear arms travels with the person across state lines as a matter of constitutional protection, not legislative grace. When a person is legally entitled to possess and carry a firearm in their home state, that constitutional entitlement does not disappear when they cross into another state. The destination state can still regulate where you carry the firearm once you exit the vehicle. But the destination state cannot arrest you for having a loaded, accessible firearm in your vehicle simply because that state has stricter vehicle carry requirements than your home state, or than the Constitution now permits any state to impose on present vehicle operators. The Virginia-Maryland-Delaware Corridor. Before Hargrove, driving from Virginia through Maryland to Delaware with a loaded handgun in your center console was potentially a felony charge in Maryland. Hargrove eliminates that risk for present vehicle operators. Your right to keep a firearm in your vehicle travels with you through Maryland, regardless of Maryland's statutory requirements. Maryland's passenger compartment storage requirements are constitutionally void as applied to present operators, making them unenforceable before you even add the interstate travel dimension. Hargrove and FOPA. The Firearm Owners. Protection Act of 1986 provided a statutory safe harbor for interstate firearms transport. If entitled to possess in both origin and destination states, you can transport through intermediate states in a locked container, unloaded and inaccessible. Courts had interpreted FOPA narrowly. Stops for gas or food could void protection. The ATF's April 2026 deregulation package clarified that reasonable journey stops do not forfeit FOPA safe harbor. Hargrove makes FOPA's protections broader and more secure. A present vehicle operator does not need to rely on FOPA's requirements because Hargrove's constitutional protection is broader for present operators. FOPA's framework continues to guide situations where the operator is not present when the vehicle is parked and unattended. Number 3, the 4 legal traps that Hargrove did not fully resolve. Trap 1. The unattended parked vehicle. Hargrove's protection applies when you are present in or immediately adjacent to your vehicle. When you park, walk into a restaurant, and leave a loaded firearm unsecured in your center console, you are no longer present. Hargrove's protection does not extend with the same force to unattended parked vehicles. California, New Jersey, Massachusetts, and Colorado have specific laws targeting firearms left in unattended vehicles. Whether these laws survive Hargrove for brief stops, a 20-minute restaurant visit, versus extended absences, overnight airport parking, is not clearly resolved. The court explicitly declined to address unattended vehicle storage in detail. Until courts address this question, the prudent approach is to secure your firearm when leaving your vehicle unattended for any significant period. Trap 2. The exit from sensitive places. Hargrove protects your firearm in your vehicle. It does not protect your right to take that firearm everywhere you exit the vehicle. The moment you leave your vehicle at a location where carry is restricted, a school, a courthouse, a federal post office, you are subject to that location's carry restrictions. This trap catches drivers who have become accustomed to their vehicle carry protection and forget the protection is vehicle-specific. The Federal Gun-Free School Zones Act extends 1,000 feet from the school property line. Your vehicle parked near a school may itself be in a restricted zone depending on how courts interpret the GFS-ZA's vehicle exception post-Hargrove. Know which locations require you to leave your firearm securely in the vehicle before you exit, and know which locations restrict even vehicle proximity. Trap 3. Rental vehicles. Hargrove's protection applies to vehicle owners or lawful operators. You are not the owner of a rental vehicle. You are the lawful operator. The ruling uses owners or lawful operators throughout, and most firearms attorneys believe rental vehicle operators are covered. But this has not been specifically tested in enforcement actions. If you rent a vehicle and carry a firearm, you are likely protected by Hargrove, but document your status as a lawful operator. Rental agreement, credit card receipt, ID matching the rental. Trap 4. Long-duration unattended storage. If you park at an airport for 2 weeks, leave a loaded firearm in the console, and fly to California, what law applies to that firearm for those 2 weeks? Hargrove addressed present vehicle operator protection. It did not address long-duration, unattended vehicle storage. For brief stops, the ATF's FOPA clarification provides guidance. For extended unattended storage, secure the firearm before leaving the vehicle for any extended period. The secure storage requirement for unattended vehicles is the one vehicle firearm restriction Hargrove did not eliminate. Number 4. The employer parking lot and private property dimension. Private employer parking lots. Hargrove's vehicle extension doctrine is a constitutional holding applying the Second Amendment to government restrictions on vehicle carry. Employer parking lot policies are private party restrictions, and the Second Amendment historically applies to government actors, not private employers. Hargrove does not directly prohibit private employers from restricting firearms in their parking lots. Several states, Texas, Florida, Oklahoma, Louisiana, North Dakota, Maine, Minnesota, Mississippi, Kentucky, have enacted parking lot laws specifically protecting employees' right to keep firearms in vehicles in employer parking lots. States without these laws, California, New York, New Jersey, may allow employers to prohibit vehicle firearms in their parking lots, and Hargrove does not directly change that as applied to private employer lots. State parking lot law status. Parking lot laws in protective states have reinforcement from Hargrove where they exist. If your state does not have a parking lot law, your employer may legally prohibit firearms in their parking lot, and Hargrove does not directly prohibit them from doing so. Private commercial lots, shopping malls, restaurants, entertainment venues, similarly can post firearms prohibited signage that applies to vehicles in their lots under private property rules that Hargrove's constitutional analysis does not directly affect. Number 5. The traffic stop framework after Hargrove combined with Cruz versus United States. The Hargrove plus Cruz combination. Hargrove June 5th and Cruz versus United States June 20th worked together to create the most protective legal framework for armed drivers in American legal history. Hargrove establishes your firearm in your vehicle is constitutionally protected. Cruz establishes the presence of your firearm cannot be used as justification for searching your vehicle, extending your traffic stop, or disarming you during a routine stop. Together, you have the right to have the firearm there, Hargrove, and the officer cannot use the firearm's presence against you, Cruz. Traffic stop protocol. When stopped, park, turn off engine, roll down window, hands on steering wheel at 10 and 2. When the officer approaches, narrate your movements. Officer, my license is in my wallet in my back pocket. My registration is in the glove box. I'm going to reach for them now. Is that okay? If you have a duty to inform obligation in your state, officer, before I reach for anything, I want to let you know I have a firearm in my vehicle. It is in my center console. How would you like me to proceed? After providing documents and any required notification, the encounter returns to its traffic-related purpose. Under Cruz, the officer cannot extend the stop to investigate your firearm, order you to hand over your firearm without independent reasonable suspicion, search your vehicle because of your firearm, or escalate the encounter based on your firearm's presence. If the officer attempts any of these, officer under Cruz versus United States, June 20th, 2026, my lawful firearm possession cannot be used to extend this stop or justify a search. I am not consenting to any search of my vehicle. Duty to inform after permit elimination. With permit systems eliminated under Carson and Coleman, duty to inform laws that were predicated on permit holder status have changed. In many states, duty to inform required permit holders to notify officers. With permits eliminated, each state is clarifying through Attorney General opinions whether duty to inform now applies to all carriers or only to those who had permits. Know your state's current status before carrying in any state. The notification obligation varies, and the consequences of failing to notify when required can be serious even when Hargrove protects your vehicle carry. Number 6. State-by-state impact and ammunition dimension. Most significantly affected states: California, New Jersey, Massachusetts, Maryland, Connecticut, Hawaii, Delaware, Rhode Island, and Illinois had the most restrictive vehicle carry requirements. All required unloaded firearms in locked cases or trunks, all struck down for present operators by Hargrove's home extension doctrine. California DOJ issued guidance July 1, 2026, acknowledging Hargrove's impact on Section 25,400 and suspending enforcement of passenger compartment restrictions for present operators while maintaining unattended vehicle provisions. New Jersey's Attorney General acknowledged Hargrove's impact while announcing plans to challenge Hargrove's application to New Jersey's specific statutory framework. Constitutional carry states: Texas, Florida, Georgia, Arizona, Tennessee, Ohio, Indiana, Missouri, Oklahoma, Kansas, Kentucky, Alabama, Mississippi, Louisiana, Arkansas, South Carolina, North Carolina, West Virginia, Montana, Wyoming, Idaho, Utah, Alaska, and other constitutional carry states had already permissive vehicle laws. Gun owners in these states are largely unaffected by Hargrove because their state's laws already permitted what Hargrove now constitutionally protects. Interstate corridors most affected. The I-95 corridor from Virginia through Maryland, Delaware, New Jersey, Connecticut, and Massachusetts was one of the most dangerous for armed travelers before Hargrove. Routes crossing between permissive and restrictive states, Ohio to New York, Virginia to Massachusetts, Nevada to California, are now safer for armed drivers. Ammunition in the vehicle. Hargrove's home extension doctrine protects loaded firearms in the passenger compartment, which necessarily includes ammunition loaded in those firearms. The New Jersey law requiring ammunition to be stored separately from firearms in vehicles is struck down by Hargrove to the same extent as the locked container requirement. Spare magazines can be stored wherever the operator decides is most accessible. Whether magazine capacity restrictions apply to vehicle-carried magazines in states with such restrictions is unresolved, where those magazine restrictions remain independently valid. Number 7. Your complete action plan before your next trip. Know these 5 things before every trip. First, know whether your firearm is protected under Hargrove's home extension doctrine. It is, if you are the vehicle's owner or lawful operator, you are present in or immediately adjacent to the vehicle, and the firearm is a commonly owned arm not subject to independent classification that removes it from Second Amendment protection. Second, know your duty to inform status in your home state and in every state you will travel through. This framework has changed post-Carson and post-Coleman and varies state by state. Research before you travel, not during. Third, know the sensitive place restrictions in your destination and intermediate states. Hargrove protects the firearm in your vehicle on the road. It does not protect you at the locations you drive to. Know which locations require leaving the firearm in the vehicle and which constitute sensitive places where even vehicle proximity may be regulated. Fourth, carry documentation. Bring the firearm's purchase record, your current identification matching the vehicle registration, rental agreement, if in a rental vehicle, and a printed one-page summary of Hargrove v. Ohio, June 5, 2026, and Cruz v. United States, June 20, 2026, noting their core holdings. This documentation makes any traffic stop resolution faster and provides legal context for the officer. Fifth, know your traffic stop protocol cold. Present, narrate, notify if required, provide documents, wait for officer's decision. Under Cruz, the firearm's presence cannot extend the stop. Under Hargrove, the firearm is constitutionally protected in your vehicle. Both holdings together give you the framework for a constitutionally sound encounter. Secure storage for unattended periods. For periods when you leave your vehicle unattended, develop the habit of either securing your firearm in a vehicle-mounted quick-access safe, center console models or under-seat mounts that are accessible when present and more secure when not, or taking your firearm with you in a holster or bag if you are carrying in the location. The unattended vehicle gap in Hargrove's protection is real, and the safest navigation is to secure the firearm or carry it on your person. For resistant states specifically, if traveling through California, New Jersey, or Massachusetts, states that are challenging Hargrove's application to their specific frameworks, pre-identify a firearms attorney in each state before you travel. Have their contact information in your phone. If stopped and the officer attempts to arrest you for a vehicle carry situation Hargrove protects, your immediate next call should be to that attorney. The constitutional protection will be vindicated, but the process is faster when you have counsel immediately available. Join the organizations that litigated Hargrove. The Firearms Policy Coalition, Second Amendment Foundation, and Gun Owners of America coordinated amicus support for Hargrove's Supreme Court petition and are monitoring Hargrove compliance, challenging state resistance, and developing litigation strategy for the open issues Hargrove left unresolved. Unattended vehicles, rental vehicles, parking lot interactions, magazine restrictions in vehicles. Your membership and financial support funds both the legal monitoring and the future challenges. Bottom line, Hargrove v. Ohio, June 5, 2026, 9-0. Vehicle carry is constitutionally protected to the same degree as home carry when you are present in or immediately adjacent to your vehicle. The home extension doctrine. A vehicle occupied by its owner or lawful operator is a mobile extension of the home for Second Amendment purposes. States cannot require locked cases, unloaded storage, separated ammunition, or trunk storage for present vehicle operators. The firearm can be loaded, accessible, and in the passenger compartment, constitutionally protected. Interstate travel. The constitutional right to keep firearms in a vehicle travels with the person across state lines. A person entitled to possess and carry in their home state retains that entitlement while traveling through other states. The 4 unresolved traps. Unattended parked vehicles. Hargrove protection reduced when operator not present. Exit from vehicle at sensitive places. Protection ends when you leave the vehicle at a restricted location. Rental vehicles. Likely protected but not fully tested. Long-duration unattended storage. Secure the firearm. Employer and private parking lots. Hargrove does not directly address private employer restrictions. Parking lot laws in protective states, TX, FL, OK, LA, etc., are reinforced by Hargrove. States without parking lot laws may still allow employer parking lot restrictions. Traffic stops after Hargrove and Cruz. Firearm protected in vehicle, Hargrove. Firearm cannot be used to search, extend, or escalate the encounter, Cruz. Narrate movements, provide documents, notify if duty to inform applies, assert constitutional protections if officer attempts unlawful escalation. State impact. Most significant for CA, NJ, MA, MD, CT, HI, DE, RI, IL. All had vehicle restrictions. Hargrove struck down for present operators. Constitutional carry states largely unaffected. Interstate corridors through restrictive states now safer. Your action plan. Know the protection and its limits. Know duty to inform status in travel states. Know sensitive place restrictions at destinations. Carry Hargrove and Cruz documentation. Know your traffic stop protocol. Secure firearm when leaving vehicle unattended. Pre-identify civil rights attorney for resistant states. Join FPCSAFGOA. Subscribe because Hargrove versus Ohio is generating enforcement challenges, state resistance, compliance petition filings, and new court questions about its open issues across the country, and every development directly affects every gun owner who keeps a firearm in their vehicle. Your car, your firearm, your constitutional right. Hargrove made it permanent.